Welcome to GTP TV. My name's Bryan and I'm the Business Manager at Green Taylor Partners. The presentation today is part 3 of the Rights and Responsibilities of Employer series. Today I'll be focusing on the most frequently asked questions on awards and employment arrangements. To start off with, what role do modern awards play in Victoria? Most Victorian businesses are now covered by a modern award. The modern awards commenced in January 2010 and are industry or occupational based employment. They were created to establish one set of minimum conditions for employers and employees across Australia. There is a miscellaneous award which covers employees who are not covered by another modern award. It's likely that new innovative jobs which are developed over time will not fall neatly into the existing industry awards. What is an enterprise agreement? The Fair Work Act 2009 commenced on the 1st of July. New agreements under the Act are now called enterprise agreements and are simply an agreement between one or more national system employers and their employees. What must an enterprise agreement contain? The major new features an enterprise agreement must have are a nominal expiry date of not more than 4 years after the day on which Fair Work Australia approves the agreement, a dispute settlement procedure, a flexible term so the employer can agree to vary the agreement to meet mutual needs, a consultation term which requires the employer to consult with employees on major workplace changes likely to have a significant effect on them, common law employment contracts, letters and offers of employment. Common law contracts are individual employment agreements between employees and their employer, with legal obligations for both sides. A contract consists of mutual promises made by two or more people enforced by law. In a work context, the most obvious form these mutual promises take is the employee's promise to work in return for a promise to pay certain wages. Unlike awards and other formal workplace agreements, a common law contract may be in writing, oral, or partly written and oral. Oral contracts often suffer from uncertainty. It's recommended to be put in writing. Common law contracts at a minimum must meet or exceed conditions in an applicable award or agreement. The national employment standards also override any less favourable terms in common law contracts. Common law contracts can be a short letter of offer or letter of engagement that summarises the employee's paying conditions, which they sign before they begin work. The new workplace relations system. The new Fair Work system replaces the industrial relations system previously known as work choices. The major changes to the industrial relations systems are: there's a new unfair dismissal laws. Enterprise agreements are the new form of collective agreement. New right of entry rules and permits for union officials. Good faith rules for enterprise bargaining, e.g. parties will be required to attend meetings and share information in a timely manner. 2 new federal workplace agencies, Fair Work Australia and the Fair Work Ombudsman. Modernised national award system with wide coverage. These are the modern awards. The Better Off Overall test for assessing new enterprise agreements, replacing the No Disadvantage test. All enterprise agreements have to pass the Better Off Overall test when compared to applicable modern awards. 10 national employment standards replace the Australian Fair Pay and Conditions standard and apply to all employees. To find out more information, you can contact Fair Work Australia info line on 131394 or log on to the Fair Work website for further information. Thank you.